to cover a little bit briefly on the open meeting law and public hearings, and then we'll get into conflicts of interest and hopefully get through due process and get us out in 30 minutes. All right. So the first slide, again, this is a repeat slide from the prior, I guess it was March meeting or April meeting, excuse me. The Tennessee Open Meeting Act, again, for public bodies in Tennessee, there are legal requirements of procedure that must be followed, and these will supersede any provisions in Robert's Rules of Order or other adopted systems that you might have, the county might have adopted. The Open Meetings Act, TCA 8-44-101, is the basis of these legal requirements for meeting procedures. And the purpose is really to implement the policy of the state that the formation of public policy and decisions is public business and shall not be conducted in secret. This is also, as you probably have heard it, the Sunshine Law. And the act covers matters like notice requirements, the contents of minutes, public voting requirements, allowing public participation, the definition of a public meeting, and the restrictions on electronic communications of members.
Who passed these?
The state.
And do they follow these?
No comment. So defining a meeting as the the Open Meetings Act. So all meetings of any governing body are public meetings open to the public at all times. A governing body includes the Planning Commission and the BZA. It's any member of a public body consisting of 2 or more members with the authority to make decisions for recommendations to a public body on policy or administration. And a meeting means the convening of that body to make a decision or to deliberate towards a decision on any matter. It does not include any on-site inspection of a program or project. And deliberating generally means weighing arguments for and against certain courses of action. So those were the repeat slides just to set the basis. Now I'm gonna present a little bit of new content that Candy did not get to at the presentation. So for the requirements for public comment, so since 2023, there have been public participation requirements for open meetings. So you probably have noticed that there's been some changes to the agendas. And so for each meeting, you must, 1, reserve a period for public comment on matters that are germane to the items on the agenda for the meeting. You must provide information about how a person can let you know they want to comment, and take all practical steps to ensure that opposing viewpoints are represented fairly, if any. Now, the body can put restrictions, reasonable restrictions on the period for public comment, such as the length of that period, the number of speakers, and the length of time that each speaker will be allowed to provide a comment. You may require a person to give notice in advance if they want to provide comments at a meeting, similar to your sign-in sheet. The public comment requirement does not apply if there are no actions on the agenda. It also doesn't apply if it's a disciplinary hearing.
So when we were dealing with the rock quarry people, the county attorney, at the first meeting, I told people in the rock quarry audience to pick 5 or 6 of their best speakers to speak. And then between that meeting and the next meeting, our county attorney told me I should let them all speak.
I think the best mechanism or process is to set and hold a standard throughout and not very basic.
I'm going to. How much on wavering?
Well, I think maybe let me clarify by saying prior to that meeting, if you had that set in place and carried through, it would have been a different viewpoint than for that case in particular. Okay. Yeah. So if you were to today say, we recommend that we set a length of time and a number of speakers.
You're talking about as like this body votes on that, or whenever we have that type of.
I think it's like a matter of practice, almost like your bylaws would be a good place to consider how you handle public comment. I think they're old.
I went by the same time limit that the county commission did. If y'all remember, I gave them 5 minutes. But, because I had asked, what does the county commission do? And that's what I was told, so I stayed there.
Mm-hmm.
I was just gonna, like I said, I wanted them to have their best speakers, you know, and stuff. And I even told them to go out in the hall, if you remember, you know, vote for who, you know, y'all pick who y'all wanna speak. I'm not gonna pick them. But pick someone who's gonna do a really good job for you, you know, because speakers can come up and kill your whole, you know, of what they say. They could turn more votes against them, the rest of them, than they can persuade sometimes.
Well, I think we had two that really kind of gave good, maybe 3 that gave good, and then everyone came up behind them and was like, well, they've already said everything I want to say, I just want to say that I agree with what they said.
Right.
Well, it says here, opposing views.
Mm-hmm.
I don't think the law says that we have to give everyone who has the same view a right to speak.
Well, again, that's what Beller told me to do, that second meeting.
Well, and at the same time, everything we did during those meetings has held up in court thus far, so I find it hard to argue with you.
No, I think we did it right. I think if we'd done it the other way, we would have done it right. But the only thing that they were trying to say was because I was giving them 5 minutes, they wanted me to limit the petitioner to 5 minutes.
Yeah.
And of course, they have the right to take as much time as they want. They're presenting their case for why they want this development. And I can't limit them.
Difference between
Yeah.
our meeting and.
Mm-hmm. Yeah. Yeah. There's a difference between a meeting and a hearing. Yeah.
Okay, I'm sorry, go ahead.
No, you're fine. That's what this is for. So other requirements to think about with the Open Meetings Act. Don't forget to consider how the space is accessible to the public. While there are no specific law, the courts look at the circumstances to make sure the public had fair access. A room that would only hold staff is probably too small. So you should try to meet in a room that will accommodate the reasonably expected numbers of the public and access to the media. And then if needed, take any reasonable steps to enable any overflow crowd to hear the meeting. I was recently in a community where they had 300 plus people in a room that only was legally allowed to have 150 people in the rooms. They had to postpone the meeting for that. So what happens when the Open Meetings Act is violated? So if a meeting is held in violation of the act, any action taken is void and of no effect, except for commitments affecting public debt,
Who
which
determines that that meeting was in violation?
the court. yeah.
So somebody would have to bring an action against the whatever was meeting
Yes, and
prove it in court.
prove it in
Okay.
court. Yep.
Okay.
This includes any violations such as failing to record minutes. So you would have to redo the whole action, including providing new notice and public comment. Even if there is a redo, the court can issue a permanent injunction against any person who violated the act. And after any violation, the court keeps that jurisdiction for a year and require follow-up reports. So really what this boils down to is don't violate the act so that the court doesn't,
Don't get the court
yeah,
involved.
don't get the court involved. So once the court is involved, violators are also subject to contempt of court, and the governing body may be subject to pay any reasonable court-awarded attorney's fees incurred against it. All right, so public hearings. So this is where it gets the difference between public comment and public hearing. So all meetings must be public meetings with the opportunity for public comment on the agenda items, but public hearings are specifically required in certain circumstances. So for instance, the state law requires a public hearing before the planning commission adopts or amends the subdivision regulations. The commission must hold a public hearing on the development of a comprehensive plan to provide an opportunity to participate in the plan's formation on the front end. And then before the adoption of any zoning amendment, the legislative body is required to hold a public hearing. So when you see the ordinances, you see when the meetings are held and then the public hearing date. So again, make sure these hearings are properly noticed and open to close as part of the business of the meeting, even if no one shows up, which y'all don't often have to do. But if you were to hold a public hearing if you were to adopt or amend the subdivision regulations, or if, I know one of the items on y'all's to-do list or wish list is update your comprehensive plan. Yes,
The section there before about the documents. Audio part, that's not referring, that's only referring to the commission.
yeah, only the county commissioners can adopt and amend the zoning ordinance. Y'all, this body makes recommendations for that, yep. All right, so public participation. For all matters of public participation, the immediate goal is to comply with the law. But the overarching goal, of course, is to ensure that the public is adequately informed and can participate in the process in a meaningful way. Another item to be aware of is that some grant funds that are available to local governments require public participation. So always be aware of, if you're applying for and receive state or federal grants, it often is going to have an element of public participation required that you must comply with. If your community is informed of what is going on around them, they are more likely to work with you to achieve the goals and objectives of the planning commission and the county than against. And as you think about matters that require public participation or matters you just want the public to be more involved in, consider the mechanisms to keep the public informed. So surveys, articles, radio and television, social media, program presentations, making yourselves as planning commissioners available to the public meeting like rotaries and chambers to inform them of what's going on and all the development and how your role is in that element of the county's growth. So, so thinking about moving right into presentations of planning programs. So aside from the official setting of the public hearing, community presentations are often a valuable tool for sharing information with the public. So I know one of the things that this body worked through like a year ago was the materials. So thinking through, were there ways to handle that or maybe make it differently when it got to the county commission? But planning commissioners and staff should be available to civic groups, schools, and other organizations for speaking engagements to express the goals and work of the commission. This helps build that consensus and support for the work that you all do and for what the county does, so that if and when it goes up to the legislative body, the elected body, there's that support that's already there and knowledge of it. These presentations can lead to informed, interested groups that can prove to be an asset in times of important decision-making on future community developments. And then just being available and transparent is always a plus for the community. So any other questions on the Open Meetings Act? All right. Conflicts of interest. All right, so a public official has a fiduciary duty to act solely in the interests of the public. A conflict of interest arises if the public official can receive a personal advantage by taking an action in their role as a public official. So there's a law that applies if you have authority to vote on work contracts the public body is involved with. There's the TCA state statute there. There's also a specific disclosure law that applies to members of a planning commission, and they must file statements with the State Ethics Commission. Y'all do that every year along with your training. And that's Tennessee Code Annotated 8-50-501. And then every public official has the duty to avoid a conflict of interest, because most public official positions in Tennessee are part-time. It's understood that there may be times when you are asked to vote on a matter which you or your family member or close friend might have a private interest. And so it's really important to always consider not just what is legal required when you speak of a conflict, but also the perception of conflicts and being aware of that from the community. And local governments may have specific conflict requirements as well. So if, I don't believe Trousdale has additional specific conflicts of interest that it requires. That's above and beyond the state.
We got conflicts.
But conflicts of interest. All right, so procedure for conflicts of interest. So the first step, I think, like thinking through this as a process, is consider what type of interest you have. Is it a direct interest? Is it a business you have control over? You could benefit from it? Or is it a indirect interest? So a close relative or friend could benefit, or a business that you may have an interest in but do not control that benefit or that how that impacts. So that's step one, determining if you have a direct interest or an indirect interest. And then the second step is determining whether you are disqualified from voting. So if it's a direct interest, you're always going to be disqualified from voting. And you should recuse yourself from that item on the agenda. Most of the time on an indirect interest, it's best to recuse yourself just to reduce that perception of a conflict. And then if you always have a question, you can reach out to staff or the county attorney and pose the question, ask and get their opinion, and then abstain or recuse yourself from voting as well. If you do have a conflict, you should not participate in any of the discussion or the voting. So just want to be clear. So before any discussion of the matter or of that agenda item, you should announce that you have a conflict and whether you will be voting. So again, if it's a direct conflict, you should abstain and recuse yourself from that item. If it's an indirect, that's where the gray area is. My advice is always just, there's really no benefit unless for some odd reason there's not a quorum present and it's very minor. Then you could state the conflict and say that you're voting. Or if there is enough of a quorum, you can recuse yourself. If you're abstaining, make sure it's clear in the minutes. So this is a good thing for the secretary to always make note of who is going to abstain from the vote. Now some jurisdictions, and I will say coming from North Carolina, this is something that we always practice was, you may be asked to remove yourself from the board and sit with the general public during that item. And then when that item is done voting, you can come back to your seat on the board. It's a preference, not a requirement.
I noticed that in Tennessee.
Yeah. Some states do, just to, again, create that differentiation, that degree of separation. So again, some jurisdictions may ask you to sit as a member of the public during discussion and while they vote, and some organizations even require a conflicted person to leave the room. So just being aware of it. All right, so some hypotheticals. What if you need to bring a matter before the board about your own property?
Well, I did that just last, 4, 5, 6 months ago. The farm I was related to, and I told everybody up front that I and my cousins owned it, and I was recusing myself and sat here, it's quiet.
There's a perfect, didn't even have to have a hypothetical.
No, I mean, well, that's pretty neat.
Mhm.
That's right. That's right.
So what about your daughter-in-law's business? Does it matter if she's just an employee?
Well, that's a great, it could.
It really goes down to direct and indirect, but then also the perception of a conflict.
And so technically, everything we vote on any spending, all of us have an indirect conflict of interest. The way the county attorney has approached it as well, you're elected members and the decisions have to be made.
I was about to ask, do y'all still have to read that?
Yeah, if it's a direct conflict, or we feel it's enough of an indirect, might. We give a little phrase about our coding our conscience, no matter what personal, benefits to the code.
Mm-hmm.
Something that all happens.
They made us, at that time, when I was on the county commission, I was a school teacher, principal. And I had to read that statement because obviously the budget they were passing affected my salary.
Mm-hmm.
That type of thing.
I still find it.
Very, very little of my salary.
The principle is actually the carrying of budget and plan,
Right.
but that's not a conflict of interest.
I mean, they have to read that statement.
Yeah.
Yeah.
I mean, it happens in very small communities that everybody knows everybody or is related to somebody that has land. So it is not unheard of, and it actually is very common. So I think it's, again, think the statement that the county attorney came up with at the time, it still continues as a good practice. All right. So what about something that might happen in the future? So what if a rezoning that would make your property more attractive to developers?
How do you work with a mic?
It's not just me voting on that.
Mhm.
It's 19 other members. I don't see how a mic in the future would affect me from voting on it at the time.
Yeah.
It's like 141. Yeah, we've known that road has improved since like
30 years.
Yeah. So anyone who was buying property could rezonings. If you were part of the county commission or the planning commission, you were gonna eventually at some point maybe benefit from that.
Mm-hmm.
But the state could have pulled funding from that project at any time and
Or never done.
or never done it at all.
Yeah.
That's like David. David's been on the county commission for years. That road goes right through 2 pieces of his property. I mean, and like I said, it's been like 25,
Yeah.
30 years. What, what's he supposed to do? Just,
I think so. In that instance, in that very specific one, is if the county were to say, we recognize the road, we're going to rezone all the land around it to,
well, the good thing
X.
is they didn't rezone anything.
Well,
They
that's
just
what-
stole his property and gave him what they thought it was worth.
well, that's TDOT.
That's all.
That's
the state
TDOT.
just stole his property and paid him what they thought it was worth. Nothing's been rezoned around that road yet.
Yeah, so if the county had said, we're going to rezone all the land around that, because we want to make sure we set the standard for what the type of development we want around the new facility, that would be the point where David would have to recuse himself, because it creates a financial interest.
Yeah.
Yes. All right. Any questions about conflicts of interest? All right, due process. So due process generally means that the powers of government, such as planning commission decisions, must be exercised with adequate safeguards to protect the rights of individuals. And then without that proper due process, the actions of the planning commission or other bodies of governance can be voided. So it goes back to y'all's discussion on the rock quarry and standing up in court. And this is one of the reasons why, is the due process includes things that we've already discussed, like the rights of the members of the public to have notice on an issue that affects them, the opportunity to be heard. It includes the right of a member of the public to have its officials fulfill their duties without conflicts of interest or other impropriety. And it often includes the right to appeal. So the appeal of a public body's decisions and access to the court system for further relief. So when due process is followed, the decisions of public bodies are given a much greater, opinions by the court. So they defer to and look at your minutes, the records, how you made your decisions.
I guess we'll find that out.
Yeah.
Appeals court rules.
That's something very interesting, is I watched a video of the full session from the appeals court and how they were. It was funny because I found it interesting that the judges were actually looking restructured, the way everything was handled from the county's perspective.
Mm-hmm.
And then we're actually giving us grace and putting the burden on the court attorney to, are you sure that's what they need? Based
Mm-hmm.
on everything that's laid out here, do you really think that they wanted, because they didn't, you know, we didn't have a specific place for it,
Mm-hmm.
that we could just randomly put it anywhere?
Yeah.
It was really kind of pushing back on them. That doesn't, you know, it was one of those, when you see that they had this and they didn't do this, but do you really think that that was their intent? There was two of them that were really hammering. You really believe that was their intent?
Mm-hmm.
And so
We'll find that out if they ever rule.
by July, we should be able to,
Oh, is that right?
yeah.
Yeah. So typically when there's an appeal, they're really looking at the records of the government body. What was the actions that were followed? What was the noticing? What were the minutes? And documenting that was due process followed. And so
That's why it's so important. I think that's why the minutes are so
Mhm.
important.
the minutes are very important.
Oh, you do a great job. Karen. And you do a great job, and I don't remember who it was during and Mary Ann did a great job.
So, again, y'all are doing it. And y'all don't actually have annexation, so you don't have to worry about that. There's a new 21-day notice for annexations. It used to be 15 days that they just changed this year. So you don't have to worry about that now. So ensuring due process, again, certain steps must be taken where public hearings, and we're going to public hearings, are concerned. So this is, again, if you amend or adopt the subdivision regulations, amend or adopt a new comprehensive plan, and then for the Board of County Commissioners, if they amend or update the zoning ordinance. So we're talking about public hearings for those. So provide adequate notice of any public hearing, make sure the venue is appropriate and that adequate time is provided for public comment. Follow your specific procedures like notice to applicants, letters to property owners, signs on the property. For subdivisions, applicants must be specifically notified about the hearing on their plat. Provide staff reports and other information gathered by the planning commission to the public well in advance of the hearing. The public should have had the opportunity to hear and see everything considered by the commission. Make sure the minutes reflect the findings of fact to support the commission's decisions, and any other materials may be included too. So again, when we talk about findings of facts, what's your rationale for making your decision? That's often something that you want to make sure is included in your motion when you make those motions. And then avoid any appearances of impropriety. The decision must be fair, impartial, and objective, made by members who are open-minded, free of entangling influences. You can tell that Candy wrote that. And capable of hearing the weak voices as well as the strong. So it's again, making sure that you're open to the public, and and that's why it goes back to, they call it the sunshine law. All right. Any questions on due process? All right. This is I love this word, ex parte. Ex parte communications. So ex parte means one side only. So it's typically like, I like to think of it as the parking lot conversations that happen. Or I saw you in the grocery store and we just happened to start chit-chatting, and then we delved into that thing that we're going to be in that meeting with each other that I really want to get your opinion on. Those are ex parte communications. So its contact is considered as ex parte if only one side of an issue is involved and all parties are not properly notified of that contact. Ex parte situations could raise an appearance of impropriety. And if you find yourself confronted by a possible situation, you should, one, refuse to be obligated to a particular side of any issue prior to a formal meeting of the commission. Insist that any and all information offered to an individual planning commissioner be presented on the full commission. So if you were to receive an email from your neighbor Joe, who's like, hey, I saw like this thing that's affecting me. I want to just share my thoughts with you. Share it with, put it into the record of the meeting. Where possible, make sure all on-site reviews of a proposed project are made by the full commission or by a committee of commissioners, not by individuals. So like if you're like, I just wanted to pop by and drive by the site, it's one of those things it's best to do as a group, or as like a committee. Because what you don't want to do is form an opinion prior to, and this is especially really important for the BZA, that they don't go out and do site visits and form an opinion. They are required to hear the findings and the facts in the meeting because they sit as a quasi judicial board. All right. Do you guys want to do some more hypothetical? All right. So the question is are these ex parte? And if not, if they are, what should you do? So an applicant speaking to you at the grocery store about how the board will deliberate on an application.
See, it depends on how they answer that question. If they're just asking, what's the process? You know, they're going to do a meeting. They want to know how the committee, operates, do I have to sign in? Do I have to, that's not illegal. You're just explaining how the process works.
Correct. But if they start asking you, how do you think the board is going to vote? Then you get into ex parte. A constituent emailing you, urging you to vote against something and attaching pictures for you to review.
I don't see how it could be because we got no control over what they send us.
It goes back to bringing it to the meeting and putting it into the record.
All those hundreds of text messages I got from them idiots talking about this rock quarry, I should have shared all of the death threats and all of the other, and I don't even know how to do that on a text message, but
Accusation of taking money for the taking.
yeah, supposedly I got it there to get my money, and I really need it. Mine's 19 years old.
So the best practice is if you receive something, whether for or against, with documentation, photos, whatever it may be, is to pass it to staff and they can put it into the record of the
There
packet.
ain't enough paper to print it out. Did y'all hear about stuff like that? I mean, it was, yeah, I mean, the redwood forest would have been used up.
Which is why it's also very nice if the government sets up an email for you on their system, and then they can just do open meeting and records requests, versus you using your individual email addresses.
No, they weren't asking for any information, and they said, hey, you damn idiot, vote against this.
All right, so that one is ex parte, and you should send it to Rosalie, and she will include that material and that email and those pictures into the packet so the full body can see that record. All right, so a neighbor you don't know canvassing your street, urging people to sign a petition to be delivered to the body you serve on.
I think that one's really easy.
The individual coming to your door, no problem. The conversation you get into once you open the door can become a problem.
But you also are members of the public in this county and have a right to be heard and represented.
The thing is, you shouldn't sign a petition to something you're going to vote for because your mind might change between the time you say, oh, yeah, I think that's right, and when you have to make your final vote.
Yep.
You're always getting new information and something.
Yes. So this one is, as you said, gray, iffy.
Oh, it's definitely gray. I don't sign petitions anyway, so wouldn't bother me.
Who?
I have shut the door on some dudes. before. I'm not the nicest person sometimes. I know y'all find that hard to believe.
Ah. All right, so your mom calling you and asking when the next meeting is because her Sunday school teacher wants to make a comment.
Again, that's just a
Yep.
procedural.
Correct. All right, and then staff emailing the body with the meeting packet and you have a concern about one of the items.
Depends on how far the conversation goes about.
Yes, you just say, I have a concern and I want to discuss it at the meeting, no problem.
But if you go into a lengthy,
Right.
here's my concerns and the guys have concerns.
Right.
Then that becomes,
Yeah.
When you start asking what someone else's opinion is, that's what gets you.
Right.
Yep. And it's in those instances, it's always good to bring that concern and voice it in the meeting so it's open to the public. Yep. Good job, y'all. All right. Last but not least, just giving you the appeals process in Tennessee. So it varies based on the body that makes the decision. For planning commission actions, the local legislative body has the statutory rights to override. The Board of Zoning Appeals does not review any decisions of the planning commission. So the Board of Zoning Appeals, if they're hearing an appeal regarding decisions made by the building commissioner or other official regarding zoning, and appeals can be made by any person agreed by the officer, department, board, or they are affected by the decision. Their appeals from the BZA go directly to court, and that's so that goes to the circuit court, the Tennessee Court of Appeals, and then to the Supreme Court, only if they decide
I
to
thought
pick
all
it up.
planning stuff went to chancery.
It's planning commission,
So the planning commission goes chancery, BZA goes to.
the circuit court.
Okay.
Yep,
Days already.
they sit as a quasi judicial board.
Oh, okay.
Yep. So the planning commission, y'all's decisions, the appeals of action start in court. So that goes directly to Chancery Court and then the Tennessee Court of Appeals, and then can go all the way up to Tennessee Supreme Court, but only if they choose to accept the case. And then Design Review Commission, the appeals can go to the PC, or the Planning Commission, or if not to the Planning Commission, it can go to the legislative body, and then that would then go to court. So that's the decision-making and appeals process in Tennessee, and that concludes the training for this evening.
Okay, with that. So we're just waiting on the appeals court to make a ruling.
All right. Well, we've made it through the items that I had identified as kind of a basis. Is there items of training that y'all are interested in, or you want to think about it and let me know? For next month, I can do a deeper dive into subregs and zoning, how to read them.
Well, and that's what we're working on right now.
Mm-hmm.
Rick is actually combining, if we looked at in our last meeting was that special zoning for the county where you can have mixed use.
Oh, is it like an overlay or a PUD? Was it a PUD?
No, it's not, it's predates, but, where it gets the area for counties doing it.
I think, yeah, I was about to say cluster development.
So because of the way that's set up, Rick was telling us that the state kind of put that in planning back years ago, and most places have taken it out,
Mhm.
removed it because it just complicates things. And so we're looking at, as we're doing the new combination, of actually moving that out, for those reasons that we stated. Because he was talking about a piece of property on South Park in London is running with that, where it's 25 acres is the non-developed property.
Mm-hmm.
And now all this time later, the actual original developer is going to go back and develop that 25 acres, and he can't because it's locked into
Yeah.
cluster development. But in Trousdale County, the way it's said, that those can only go in R1s, correct, Rosalie, in the county. Well, you would have to have, a large piece of land, and I guess using common, parking areas for your soil to be able to run your septic, to run multiple houses
Mm-hmm.
on it, and it just makes a cluster, honestly. So we were looking actually removing that, from the zone.
Mm-hmm.
And then there's been some other things he's run into where it doesn't fit in the zone.
Yeah.
And it has no place in zoning reg. Should be a standalone ordinance and not, that kind of stuff shown in there.
Mhm. Okay.
So we're cleaning some of that up. So when we get that done, I do want to bring all that through here, in chunks. Because the way he's doing it is, he actually, where he's combined the Hartsville side, we just went through the definitions and we're just starting to get to the zoning, actual zones. Every change he's made, he has it either highlighted and then drawn through, or he's highlighted, and because of the color, it'll tell you where it came from, whether it was the Hartsville or whether it was the,
And you think the county commission's gonna pass that?
I have no idea. He's gonna be presenting it. Every meeting, I have been very adamant, we are not trying to change anything, we're just trying to combine it in the most effective way.
Mm-hmm.
Using an outside source that everyone that I know of has high regard for. Anyone who knows him on the commission has high regard for him. So I'm hoping, that being said, that we might be able to get something voted on in January, February of next year.
Okay. So maybe hold off on the zoning and we can do sub-regs.
Actually, me, it's working through some of this.
Oh, to do zoning ordinance and
Yeah.
training?
Kind of getting the information as we're doing this with Rick, just asking questions as he brings up what he wants to do. The intent of some of this stuff that we're looking at is kind of the big thing to, why was it put in there in the first place?
Okay.
Some of the stuff was just to manipulate what couldn't come in at the time. And then when that time passed, then it got removed and chunks got left in. So we're
And
trying to clean all that up too.
And it's often a copy of a copy of a copy.
We've run into that too, where the language just didn't match up.
Or it references a section that doesn't exist. Oh, the Hartsville versus the Trousdale. Yeah. Okay.
Heather, have y'all hired a permanent water dude? Yeah. I don't know.
And then, what is your, so you are a Trousdale is a metro. You don't annex anymore like you are. You what?
Because annexed property of, Altown.
They wanna come into the urban service area.
Oh, into the urban service areas, but not to the, like, not to this municipality.
Right.
I got you. Well, I think I need to look into it. I mean, when you say annexation, I immediately jump to being annexed into a city boundary, not into a service district. And so, yeah.
Right. They just want the infrastructure.
Mm-hmm. But I don't think there's like the new state law is, I'm almost positive, I'll have to look back, is specific to coming into a municipality.
Because honestly, if you're brought in, if your property is annexed into the urban, you also get that extra tax.
Oh, okay. That's it. I will have to look into
Is
that.
our urban service area considered a municipality?
That's its own separate, voting.
I'm gonna have to investigate that. Metros are a unique little beast.
It's really hard to find training at the, three of them.
Three.
Yeah.
All of Tennessee.
Us, Moore County, and Nashville.
Yeah. Okay, I will look into that and let
And
you
not every
know.
place in Nashville, part of Metro.
No, yeah, you
A lot
got
of people don't know
Berry
that.
Hill, Bellmead, Forest Oak. I don't think they exist anymore, like officially, but I recognize that name. I think there are 5 Bellmead. Yep, I think there are 5 little communities that are not part of Metro. All right, so I've got annexation, urban, rural.
Because with 141 coming through, there's some opportunity, some of that property might want to be annexed.
Yeah.
Do you live near where the road's gonna be?
Yeah.
Oh,
She's closer than I am.
well, maybe by the road, but.
And that's another thing
Where you-
for the county commissioners in this body to think through is rezoning that property. All right. Mm-hmm. Yep.
The guy who followed that.
That, where that old store was?
No, not the store, but the farm that run behind the store and house. Farm that runs there.
Ada,
Uh,
you know who owns it?
I have to look it back up. It's a property.
Oh, that's fine.
But his name's listed on about 3 properties.
I know his family owned land out there on that, as you're going up 10 on the right.
But this is, that whole, it's usually just used for hay, but on the north side of 25, that runs.
The government can take action to rezone. I wouldn't strongly recommend it, but you can. Yeah.
We could always just have the state initiate it and, they just carte blanche, turn it all commercial.